Hello, and welcome to another episode of Law in Sarasota. I'm your host, Adam Tabrouge. Today, I'm delighted to be joined by my friend, Mark Zimmerman. Mark, welcome to the program.
Thanks for having me, Adam.
Mark, you and I have known each other for many years now. Tell me why it is that you wanted to become an attorney.
Well, I'd like to say that I've always wanted to be a lawyer, probably since I was in fourth grade. But when I was older, my older siblings, two of them became lawyers. They married lawyers, so I was around that quite a bit. That was the inspiration for going to law school.
And where did you go?
I went to the University of Florida College of Law.
How did you find that experience?
I loved law school. I loved studying law. I'd never been to Florida before, other than to visit Disney World. Before coming down to Gainesville, I was educated and grew up in the Northeast, so it was a little bit different coming to Florida, the culture. But the study of law, I really enjoyed, and of course I ultimately really loved being in Gainesville.
And Mark, tell us a little bit about your career and experiences since you graduated from the University of Florida Law School.
Okay, so I've been a lawyer here in Sarasota County for 23 years. For the first almost 9 years, I was a prosecutor with the state attorney's office here, again, of course, in Sarasota. And then for the past 14 years, I've been in private practice. For the first 7 of those years, I was alone as a solo practitioner. And for the past 7, I've been in partnership with Lori Zimmerman, who is my wife.
And tell us a little bit about the practice that you all maintain.
Well, my wife is a civil practitioner. My practice, I would say, is 85 to 90% criminal defense. I defend people who are accused of crimes. That other 10 to 15% is made up of a combination of 3 smaller areas. One of those is that I defend students who are expelled from the public school system, primarily in Sarasota County. The second one of those is that I represent people who are accused by the Department of Children and Families of child abuse or child neglect in something called dependency cases. And then the third is I represent people who both seek and are defending injunctions for protection, more commonly known as restraining orders.
So Mark, that's actually why I wanted to have you on the program today to talk about injunctions for protection and restraining orders. Tell us just a little bit more about your practice in that area before we get into the details.
Well, I do represent people privately. In other words, they pay me to either help them receive an injunction for protection against another person, or if someone's seeking an injunction for protection against them, I can represent them in that same type of proceeding. In addition, legal aid, the legal aid organization, the Minnesota County Legal Aid, I will take cases, what are pro bono cases, or in other words, representing people who cannot afford an attorney for free. And in those cases, those are people who are seeking injunctions for protection.
So Mark, when we talk about injunctions, under the Florida statutes, it's really important for the person seeking the injunction to determine what type of injunction they might be entitled to. What is an injunction, and what are the different categories that are available?
Okay, here's what I think is the best way to understand it. We live in a crowded world where people bump into each other, have all sorts of interpersonal relationships with each other, and during the course of living our lives, people do not always get along, obviously. And under certain circumstances, depending on your relationship to that person, you can go to court and seek an order, a court order, protecting you from that other person. Now, what's important to understand is that not everybody is eligible for that type of protection because, as we all know, some people on a one-time basis just have a chance encounter. That encounter doesn't go well, and those people can't go to the court and seek an injunction for protection. For example, if 2 people are in a car accident and one of them decides they're upset, they push the other person, they shove them, they even hit them. They could be prosecuted for a crime, but in that circumstance are not going to qualify to go to court because from a public policy standpoint, we don't want everybody going to court and seeking these orders for protection in these more commonplace scenarios. That said, if you have that type of chance encounter and there's multiple incidents, then the law does cover that in a type of injunction called a repeat violence injunction. Now, other people, based on their relationships, are so commonly, with each other and sort of can't avoid each other, that the courts do recognize that those people, when there's disharmony or more particularly violence or the threat of violence, then those people can seek the protection of the courts. And of course, the most common is the injunction for protection against domestic violence.
Well, let's start with that one. If someone is in a domestic relationship and they are in fear and they feel like they need the protection of the court, what's the first step for that person to take, or what are the requirements of that injunction?
Well, the first requirement is that they have to be eligible. They have to be in a relationship defined by law as a domestic relationship. And what that essentially means is they have to either be related by family or marriage or live as a family. So an example of that would be, for example, say you have a young person and their parents were divorced and they live with one parent, and that parent moves in with their boyfriend or girlfriend. Those people are still living as a family. So if there's violence in that relationship, it's say your mother's boyfriend, but you live together in the same household, that still counts even though you're not related by blood or marriage. Obviously, people, spouses, children, etc., of course, they're going to be eligible. What are the requirements besides eligibility? Well, obviously there has to be either an incident of violence. They have to be the victim of a crime of domestic violence, and there are several crimes of domestic violence. They can range from things like assault and battery to things like false imprisonment, etc. And then, of course, they have to go down. Oh, I'm sorry. The other way of getting that is to prove that such violence is imminent. And imminence doesn't mean sometime in the future, in the distant future. The idea that I think perhaps under certain circumstances violence could ensue. No, it has to be imminent.
So, Mark, that's one kind of injunction for protection, and that is if people are living together as a family. What if they're just boyfriend, girlfriend, and the relationship goes sour, and one has a legitimate fear that they might be facing violence from the other? Is that covered under the law?
It is, and it wasn't always. As you and I as lawyers both know, the law evolves. And what would happen, I would presume in the past, is that there are people who would seek or want protection from the courts, but the courts did not recognize their particular relationship. Well, over time, these injunctions for protection have evolved. So, for example, now you can seek protection from what's called dating violence. So, a couple, if there's violence in a dating relationship, then one person can seek protection from the other. Now, it cannot be sort of just a work social kind of a thing. It has to be a real significant dating type relationship.
And then, Mark, you've already alluded to another type of injunction, and that's an injunction for protection against repeat violence.
Right.
As you indicated, if there was simply one incident, that would not qualify you for the injunction. What does the law require?
Well, the most important thing is that there has to be, as its name implies, multiple incidents of violence. And of course, two will suffice. One of them has to be within 6 months of seeking the order. In addition, there are now injunctions for protection against stalking. Now, stalking is a very complicated crime and a very complicated scenario. In the past, you've been able to seek injunctions in the domestic concept and in the context and in the repeat violence context for stalking, but now and also, of course, in dating, but now you can seek an injunction for protection specifically against just being stalked by a stranger. The other thing is you can now seek an injunction for protection specifically against sexual violence. So if there's a one-time incident, regardless of the context, and there's been a sexually violent allegation, you are now able to get and seek the protection of the court from these types of injunctions, for these types of injunctions.
You know, it's a lot to keep track of, even for us attorneys. What about a lay person? Other than attorneys, is there anyone out there who helps understand the different types of injunctions that are available?
Sure. Well, in Sarasota County, obviously, we have an excellent organization known as SRQ. It stands for Safe Place and Rape Crisis Center. And SPARC works not only to help victims, of course, as it implies rape and sexual violence, but also, and I think probably even more commonly, victims of domestic violence. They have counseling services, they have shelter services, they have advocates who come to court with victims of domestic violence to help guide them through the injunction process, particularly for people who do not have a lawyer.
Well, Mark, we're going to continue our conversation in just a minute, so please stay tuned for more Law in Sarasota.
Seven 7,000 high school students drop out every school day. That's a line of desks more than 4 miles long. We can keep students in school. Visit boostup.org and take the first step.
Welcome back to Law in Sarasota. I'm your host, Adam Tabrouge, and today I'm speaking with attorney Mark Zimmerman. Mark, we've been talking about injunctions for protection and the different types of injunctions that are available. How does this whole process get started?
It starts by filing a document known as a petition. You're asking the court for something, you're petitioning the court.
And where do you do that?
Okay, you can get a petition either online. They are available online if you went to the Sarasota clerk's office. Quite frankly, if you simply Googled petition for injunction or injunction for protection Sarasota, you would probably be led to the form for doing that.
And what about at the Sarasota County Clerk's office itself? I know a lot of people tend to go down to the clerk's office.
Right, so if you go down to the clerk's office, of course there's the little placards telling you the different areas, traffic, criminal, civil, all the different aspects of the court system. One of them is for domestic violence, and even though the domestic violence injunction is only one of the types of injunctions, my recollection is that's the placard they have up for injunctions. It's all the way at the end. You go down there, you can talk to one of the assistant clerks who would assist you, give you the petition form, make sure that you fill out every aspect of the paperwork. Once the paperwork is prepared, within that day, it goes to a judge who reviews it and will make a determination.
What kind of questions are being asked on these petitions? What kind of information should you be thinking about before you start filling it out?
Some of it is obviously just basic biographical information, where you live, what your name is, things like that. Obviously, they're going to want that same type of biographical data for the person that you're seeking the protection from. So it's important to have as much of that information as you can. If you know where that person lives or where they're staying, you should have that information when you go fill out the petition. The other thing, obviously, is you're going to have to give a narrative description of the events that are leading you to seeking this injunction for protection.
And Mark, you and I have both had the opportunity to review a number of these petitions. I think we'd agree that it's probably best to put in as much detail as possible for the judge's benefit who's going to be reviewing this petition.
Sure. The form gives you a very limited amount of space, but it also says you can attach additional pages, and some people write novels. I don't know that that's necessary, but it is important to give as much detail as possible, because at the hearing, and there ultimately could be a hearing on these injunctions, oftentimes the judges will limit you to what you put in there. So if you say there was this one particular incident, and then you go to the hearing, you want to mention another incident that happened 3 days prior to the one you mentioned in your petition, you might be barred from discussing that incident.
So Mark, the person has filled out the petition for injunction. They've filed it with the clerk of the court, and now it's gone to a judge. What is the judge looking for, and what can the judge do at that point?
Well, the judge is looking to see that the criteria, the legal criteria, are met. In other words, that the person has the type of relationship as defined by the particular injunction they're seeking, and that they are seeking the proper relief. In other words, that they were in fact the victim of a crime, or that such violence is imminent, or in a repeat violence injunction, that there's been multiple incidents, that it's within 6 months, etc. Now the judge can do one of three things. They can dismiss it. They could basically say this is insufficient, and that can be for a number of reasons. It could be because the proper amount of details weren't given, or it could be because the relationship just didn't meet the criteria under the law. The judge can issue a temporary injunction. Now, let me get to that last. The second thing the judge can do is say, I'm not sure whether there's enough information to issue a temporary injunction, but I want to know more, so I'm going to schedule a hearing. And that hearing is going to typically happen in sometime in the next 2 weeks. But the most, I think, important one to understand is that the judge can issue what's called an ex parte temporary injunction. And ex parte means that they didn't hear from the other side. We of course have due process of law, and before the courts can take away a right of yours, like the right to go to your own home, typically you get to be heard. But there are exceptions to that, and this is one of those exceptions. And in a situation where the courts need to step in and protect a person, particularly from something like domestic violence, they will literally remove a person from their own home, perhaps separate them from their own children, in order to perform this other important service, which is to protect an individual. Now, because they're doing that, again, ex parte, without hearing from the other person, without giving them that due process in the short run, they are going to give them due process in a little bit more time, which is to say they're going to do it within 15 days.
So Mark, let's say that you sought an injunction for protection against repeat violence against me.
Okay.
And you went down to the clerk's office, you filled out the paperwork, it went to the judge, and the judge agreed with you and issued a temporary injunction.
Right.
How am I going to find out about that, and what will happen next?
Well, the sheriff's office is going to act as the civil process server, and they are going to literally serve you with a copy of the injunction. So it's not the petition itself, it's an actual new court document, it's a court order. It's going to have tremendous detail in it explaining to you what you cannot do, meaning you can't come within a certain distance of me, of my car, of my home, of my place of employment. It's also going to tell you what would happen to you, or what could happen to you if you were to do that. And then the most important thing I think it's going to do is it's going to tell you that there's going to be a hearing. It's going to tell you who the judge is that's going to preside over the hearing. It's going to tell you specifically where the hearing is, and it's going to tell you when the hearing is. And that hearing is going to be within 15 days of the issuing of the order. Now, you may be served with the injunction the day it's issued, the day after, or you could be served with it 14 days after, or the day before the hearing. But the bottom line is that it's going to be 15 days between the judge issuing the order and the date that the hearing is scheduled.
You mentioned what could happen to you. So let's say I was served with the court's order, and it told me to stay away from you, and I went right over to your house and started knocking on your door
Right.
to find out what's going on here.
Right. Well, judges take their orders very seriously, and that's very important, because I dare say that if we didn't have people respecting court's orders, we would not have an orderly society. So because they take those orders so seriously, one of the consequences is that you have committed now a crime. It is a crime in Florida, a misdemeanor, to violate an injunction for protection. So what would then happen is, since you've come and violated that injunction, I'm going to call the police, or I'm going to go down to the clerk's office and file a document alleging that you have violated the injunction. The result to you could be arrest, prosecution, and incarceration. It's very serious.
So even though we just call it a temporary injunction, it has all the force of law, and I need to follow that court order.
Correct. And in fact, one of the things that the courts look for in the hearings on determining whether this temporary order should become a final or permanent order is whether the respondent, the person who was the subject of the injunction, who was served with that temporary order, whether they respected it. Because if they violated it, that's going to be one of the things the courts are going to look at in issuing that permanent order.
Well, Mark, when we come back, we'll talk about what happens at the final hearing on the petition for a temporary or petition for an injunction. So please stay with us for more Law in Sarasota.
My life is full of statistics. Thing is, I could have dropped out of school and become one myself, but I didn't because I had people that believed in me. Here's another statistic. 7,000 students drop out every school day. That's one every 26 seconds. It's time that students know that we believe in them.
Inspire a student and share your message of support at boostup.org.
Welcome back to Law in Sarasota. I'm your host, Adam Tabrouge, and today I'm speaking with attorney Mark Zimmerman. Mark, we've been talking about injunctions, and we just discussed temporary injunctions and the fact that a hearing would be set. Let's talk about the hearing.
Right.
If you're the person seeking the injunction against me, what is it that you're going to need to do at this hearing?
Well, first of all, you need to conduct yourself appropriately. You know, these matters are highly emotional. We're oftentimes dealing with people who are married, going through the process of a divorce. They're dealing with issues about splitting up property, working out issues with custody and children, not to mention that there was violence. So emotions are running very high. That said, there's an expectation that everybody's going to be on their very best behavior. So it's important that people be prepared to know how one conducts himself in court. And that has to do with things as simple as dressing appropriately, acting appropriately, not speaking out of turn, learning a little bit about courtroom procedure. Obviously, if you have a lawyer, that lawyer is going to take the lead on that. If you are representing yourself, which is very common, a process known as being pro se, that's going to be a little bit more difficult process. My recommendation to a person in that situation is to sort of take it as it comes, follow the judge's lead, etc.
If you were seeking the injunction and now it's set for the final hearing, should you bring any witnesses or evidence with you?
Absolutely. This is the one time this is going to happen. Someone should not expect to show up for court, have the judge hear from them, and then have a discussion about whether or not there's going to be other evidence. No, this is your hearing, this is the day. If your neighbor witnessed something or your brother-in-law witnessed something, bring them to court with you. If you have documentations, photos, items that were broken during an altercation, etc., you need to bring those things to court with you.
When we go to court, whose job is it to prove the case? Is it yours because you're seeking the injunction, or is it mine in order to get the injunction set aside?
Right, so this is something we call the burden of proof. The person who is seeking the injunction, so in our case, that's going to be me. I've got the burden of proof, so I'm the one who has to prove it. I have to prove it by the greater weight of the evidence. Sometimes people call that the preponderance of the evidence. Sometimes people call it 51%. But the bottom line is, I'm going to present my side. Presumably, you're going to present your side. The judge needs to believe my side more, maybe even just a little bit more, than they're going to believe your side in order to get the relief I'm seeking, or in this case, obviously, the injunction.
Well, let's say that you're testifying and I don't agree with what you're saying. Should I just stand up and say that I don't agree, or am I allowed to ask you questions? How does that work?
Right, so each side has the opportunity to present their own case. The petitioner, me in this case, I'm going to present my entire case first. So typically I would testify, I would tell my entire story. While I'm on the witness stand, while I'm testifying, things that I know about, for example, if I took pictures, those are going to be presented through me. After I'm done testifying, you or your representative would get to cross-examine me. You'd get to ask me questions, any question that is relevant to this issue, to the violence, the allegations at hand. Then I'm going to get a chance to come back and talk again, something we call redirect examination, and then of course it would conclude with recross-examination. When I'm done doing that, I'm going to then have the opportunity to call any witnesses that I've brought to court, one at a time. And that same process would ensue. My witnesses would testify. You would get to cross-examine them in exactly the same process I discussed.
Well, Mark, let's say either you didn't show up for this hearing or you showed up and you really didn't testify to the things that are required by the law. Can I move to dismiss the case at that point?
Yes, absolutely you can, and typically that's going to be granted. If a person is seeking an order for protection and doesn't even bother to show up for court, then that injunction for protection is going to be dismissed. On the other hand, if you don't show up for court, I'm going to be seeking what we call a default, and I'm typically going to get my restraining order, my injunction, because it was proven that you were served and you didn't bother to go to court. Now, some judges in that circumstance might want to hear some testimony to make sure that some threshold has been met, but typically there'll be a default entered.
Well, after you testify, do I have a right to defend myself against your scurrilous allegations that you just made?
Absolutely. You're going to have the full opportunity to present your case. That includes your testifying in your own defense. And of course, I'm going to get to cross-examine you exactly the way we discussed when we had the opposite roles. If you have evidence, physical evidence, photographs, etc., you're going to be able to present that to the court. Once again, if you have witnesses, any witnesses, you're going to be able to present them as well.
Mark, any other advice for those who are seeking an injunction or defending against an injunction when they go to court?
Yeah, I mean, obviously, if a person can manage to get an attorney, whether they hire one or whether they have one appointed to them through legal aid, I think that's really important. I mean, going to court on your own is a very difficult process. I mean, there's a reason we received years of training, and of course we have years of experience in doing this. And particularly if the other side has an attorney and you don't, it creates a really, quite frankly, an unfair advantage. So that's the first thing I would recommend. The other thing is, as I said, it's really important to conduct yourself appropriately. I mean, it's so easy while in court, perhaps you hear the other side saying something that you don't agree with, or perhaps you believe they're lying and you want to talk out of turn, you want to speak out emotionally, and you think, well, this is an emotional matter, so everyone will understand. They won't understand. The judges don't understand. They don't appreciate that, and nor should they. There is a proper decorum to a courtroom, and violating that, quite frankly, can tilt the outcome of this hearing, because a judge is going to assume that you're on your best behavior in court. So if you're acting, sort of out of line, they're going to wonder, well, how does this person conduct themselves not in court?
Well, Mark, as we wrap up, we've used the term permanent injunction. Are these really permanent?
No, we do use that word permanent because, as to distinguish it from the temporary injunction. But really, the language in the injunction itself is until further order of the court. And what that does is it leaves open a lot of possibilities. One is that it does remain permanently. The other is that both sides come together in a joint decision to realize, we don't need this injunction anymore, and we want to get rid of it. And the other is that the other side, if they think that, for example, time has passed and time has healed those wounds, or some change in circumstance, perhaps someone's moved out of the jurisdiction, they can move to dissolve the injunction.
Mark, I really appreciate you coming on the program here today to discuss these very important issues surrounding injunction. May people call on you if they would seek representation in this area?
Of course, naturally. And thank you very much for having me.
Well, thank you, and thank you for watching another episode of Law and Sarasota.